Hello, this is sentencingstats.com, and I am Mark Allenbaugh. Today is August 25, 2018, and we'll be discussing today Paul Manafort's upcoming trial and possible sentencing in the District of Columbia. But before we do so, just a brief refresher on his recent conviction out in the Eastern District of Virginia. As you'll recall, he was charged with 18 counts of various forms of fraud and was convicted of 8. There was a mistrial declared on the other 10. This was the guideline that I calculated for him. I stand by this calculation primarily because the mistrial counts do not matter for purposes of sentencing. Even if he was acquitted on those counts, they would still come in at sentencing. Frankly, even if those counts didn't exist, the calculation here would remain the same based upon his 8 counts of conviction, which involved at least one count from the 3 groups of offenses that were charged. The tax fraud, he was found guilty in all 5 of the tax fraud counts, 1 of the 4 F-bar counts, and 2 of the 9, if I'm doing the math correctly, bank fraud counts. So, at any rate, his final offense level is 41. He's in criminal history category 1, at least as far as I'm aware. I haven't heard any discussion or facts that he might have any criminal history. So assuming he's in criminal history 1, his guideline range, as I had indicated before, was 324 to 405 months. But he almost certainly will do nowhere close or be sentenced to nowhere close to that amount of time. We had discussed in our prior video the 56 cases that we had identified in the Commission's data files. Sentencingstats.com has all the Commission's sentencing data, the publicly available sentencing data files from fiscal year 2006 through 2017, the latest available. Frankly, any earlier years are irrelevant because that was in an earlier era when the guidelines were mandatory, but as we all know now, since Booker in 2005, the guidelines are now advisory. So since Booker, there have been nearly 1 million people sentenced under the guidelines. 56 of them matched what I estimate Mr. Manafort's sentencing guidelines to be. Sentenced under 2B1.1, final offense level of 41, criminal history category of 1. There were 32 trials, 30 downward variances, and this is the distribution of the cases. They range from 0, or of the sentences, I should say, they range from 0 to 324 months, which was the bottom of the guideline range, meaning most of these cases received below guideline sentence. By the way, as I explained in the other video, this isn't the maximum sentence. This is what's called the upper bound as calculated by the Excel software, and it's a commonly used formula. I'll spare you the details, but it's a formula to estimate the upper bound where any numbers or any data in excess of this boundary would be considered outliers or statistical anomalies. There's something very, very odd about them, and they don't fit the regular distribution, if you will. So looking at the regular distribution of sentences for these 56, the median sentence was 168 months or 14 years. The average was just a hair under at 165 and a half months. The interquartile range was about 5 years to 20 years. I estimate, primarily because of Manafort's age, and a little bit because Judge Ellis, the judge there in the Eastern District of Virginia, did not seem to be a fan of this prosecution, that he's going to get a downward variance like most everybody else gets, but it's going to be more than the median. He's going to get around 10 years is what I estimate. And also looking at Judge Ellis's sentencing in fraud cases generally, he does not appear to be a very harsh sentencer. Out of the reviewing a sample of 30 sentences for Judge Ellis, only 2 or 3 were above the 10-year mark. So again, my estimate is that he's going to get around 10 years, certainly no more than 14 years here. The median, he's not going to get more than the median is my estimate. But all of that is academic. Any sentence greater than 5 years is a life sentence for Mr. Manafort. Why? As we discussed in the prior video, recent studies have shown that for an inmate sentenced to a long period of time, his life expectancy on average is reduced by 2 years for every year of imprisonment. So what that means is, based upon Mr. Manafort's current age, he's nearly 70, and his life expectancy, I'll return to this later in this presentation, but his life expectancy is only about 5 years. So around 2023 is maybe it for him if he's given a sentence of more than 5 years. So let's now turn to the District of Columbia. What can he expect there? And I'll just cut right to the chase. He can expect the same sentencing range. Interestingly enough, he's certainly not charged with the same offense conduct. It's different, even though it's related. He only has 7 counts here, unlike the 18 in the Eastern District of Virginia. But the primary count is the money laundering count, and that's really what's going to drive his sentence here. He's certainly charged under a general conspiracy count, and there's the unregistered foreign agent charge here, and one of these false statements is specifically with respect to his conduct as an unregistered foreign agent, allegedly. The press, I anticipate, are going to be really focused on testimony regarding these counts here, the false statements and the unregistered foreign agent, because that involves his conduct with respect to representing Ukrainian and Russian interests and what have you. But for sentencing purposes, as it turns out, that's not going to be all that relevant. It's going to be the conspiracy, the amount of money he's alleged to have laundered. And that is set forth actually in the indictment, in excess of $30 million, according to the indictment, is the amount of money that he conspired to launder. Interestingly, there's also 2 counts that were added. Just as you can see, this is a superseding indictment that was issued just this past June. The superseding indictment is very different from the initial indictment, which had other counts that aren't in this. As a matter of fact, they dropped them, but they kept. It doesn't really matter really what was in there. So with respect to superseding indictment, what is most interesting are these 2 obstruction counts that were added in. These counts have to do with witness tampering. He was alleged, he as well as his co-defendant here, Klimenik, were alleged to have been trying to talk a couple of witnesses into not testifying at his upcoming trial. It's not clear which trial, if that had to do with the Eastern District of Virginia or the District of Columbia case here. At any rate, those obstruction charges will certainly influence the sentencing. Unlike the false statements, I don't think those are going to have really any material effect on the sentence, but the obstruction will, because he's going to get an enhancement for obstruction of justice, even if he's acquitted of these counts. As it turns out, acquitted conduct can be considered at sentencing pursuant to an old Supreme Court case from 1997, United States versus Watts. Okay, so let's turn to the guidelines calculation itself. Again, money laundering is going to be the driver. That's going to be the sentencing guideline he's sentenced under. And as you can see here, it's going to be the amount of money laundered. That's going to be the main driving force of his sentence, because the amount is so high. That really pushes up his offense level. And because assuming he's convicted of the 1956 offense, which is the money laundering statute, if he's going to be convicted of anything, it's going to be of that. He's going to get a +2 there. So certainly it's sophisticated money laundering, so another +2. As I estimated in his Virginia case, because he's charged with a conspiracy, he's going to be hit with a leadership role, which is a +4, the highest under the guidelines for a defendant's role in the offense. He orchestrated all of this money laundering, and as was the case in the Eastern District of Virginia, the tax fraud, the bank fraud, etc. And as I was just discussing, the obstruction of justice charges will serve as a basis for a +2 enhancement, even if he's acquitted of those charges. So that gives him a +40. He's going to be in a different criminal history category, though, in this case, because of his Eastern District of Virginia conviction. Now, technically, he has to be sentenced in the Eastern District of Virginia first before it can be considered part of his criminal history for purposes of the guidelines, at least in the District of Columbia case. But needless to say, Eastern District of Virginia, rocket docket, Judge Ellis has moved that case along quite quickly, so I anticipate that he will be sentenced in the Eastern District of Virginia before he's sentenced here in the District of Columbia. And if that occurs, of course, then he's going to be in a criminal history category 2. So even though his offense level is one lower in this in the District of Columbia case than it was in Virginia, because his criminal history category is higher, his guideline range, as it turns out, is coincidentally the same, 324 to 405 months. So let's look first, before we get down into the nitty-gritty of those who are similarly situated to him, let's just take a quick look at sentencing generally for money laundering offenses. What we can see here, according to our data, between 2006 and 2017, there were 12,595 individuals sentenced nationwide under the guidelines. And this is overall. This is including all offense levels from 1 to 43, all criminal history categories from 1 through 6. And, of course, all modes of conviction, whether by trial or plea agreement, and includes mandatory minimums, all of that. I just mentioned those because those are things that we can filter out for or filter in depending on how one is looking at the data or what one wants to see. The average sentence nationwide for all of money laundering was 69 months, 5 years, 9 months, and the median was only 42 months. And the District of Columbia, which is where he's at, again, the D.C. Circuit and the District of Columbia, the district for the District of Columbia are geographically one and the same. There has only been 107 there, and the average sentence imposed was a little lower, only 54 months, but the median, again, is 42 months. It's the same. So let's take a look now just at sentencing nationwide. This is a snapshot of all those years at once, but let's look at the trend by year. And we can see that the median sentence of 42 months was also 42 months for 2017, just looking at that year, and it's been rather consistent. Started out as 41 months in 2006, but has remained the same. And again, overall, looking at all these years together, it's 42 months, but it's been around that for every year since 2006, so it's been rather steady. What this chart shows is the rate of judge-initiated downward variances, and what we mean by that at sentencingstats.com is the 18 U.S.C. 3553A factors that judges must consider. One of them is the guidelines, of course, but then there are the purposes of sentencing, such as rehabilitation, incapacitation, deterrence, etc. Those are the other factors that a judge must consider. And again, the guidelines are only advisory, so a judge is not required to follow them and can sentence above or below, depending on how he or she feels about particular guidelines and the case and the defendant before the court. So the downward variances here have increased slightly from about 19% in 2006 to over a quarter of the time now. Judges are sentencing below the guidelines in money laundering cases overall. So how far below the guidelines are they going? And by the way, this is, before I turn to that, to the degree of the downward variance, what's interesting here is while the increase has been modest, it's nowhere near what the increase has been in terms of downward variances, the rate of downward variances for other types of offense conduct, such as child pornography or fraud cases generally, like under 2B1.1. Those variances, the rate of variances, have increased much more than here. And for example, in child pornography cases, almost half the time now, judges are varying below the guidelines. I just mentioned that by way of comparison. Now, what this chart shows is the degree of variance. So if a judge does vary, how far below the guidelines are they going? So it was around 5 years in 2006, and it's almost 70 months now, 5 years, 10 months almost, as of 2017. But we can see in between there has been an enormous amount of variability. And this just shows an area that, a problem with advisory guidelines, if you will, that while we've given judges a lot of discretion, or I should say the Supreme Court has in the Booker case, the guidelines are no longer mandatory. What this has led to, unfortunately, is, and not surprisingly, a lot of variety in the sentences that are imposed. While it's good that judges are sentencing below the guidelines, one can't just look at that. One needs to also look at how far below they're going. And this is just nationwide. And we can see by year it's varied quite a bit how far below the guidelines are going. From 62 months in 2006 to in 2011 it was over 100, well over 110 months. So almost double. And then it's gone back up again in 2014. So this, I just note this because this is something that certainly counsel and people that are looking at federal sentencing should take into consideration and take a look at. What are the trends and how far below the guidelines are judges sentencing? This also, for a policy perspective, could present a problem too, given the variability and obviously with such variability, the chances of unwarranted sentencing disparity increase. Okay, so now this is basically an iteration of these numbers up here. One of the things that sentencing stats that we do for counsel or for clients is provide more nuanced analyses than just a simple average or a median. Here, an average or a median doesn't tell you all that much in terms, especially when you're talking about 12,000 sentences. Okay, so I know what the average is, 69 months, but does that mean an 80-month sentence is an aberration, or that a 50-month sentence is an aberration and really far below that? What does that mean when I'm trying to compare a particular sentence to the average or the median? Well, just looking at that number doesn't tell you anything. So this is why we do these box and whiskers charts. This gives, this fleshes out, if you will, that median and that average. It gives more meaning to it. So again, here's that 69-month average, and here's the 42-month median. What this box here shows you is what's called the interquartile range. What this 87 months is equivalent to is the third quartile at the top of the box, and the 17 months is equivalent to the first quartile at the bottom of the box. The third quartile means 3/4 of all these 12,000 cases were sentenced at 87 months or below. 1/4 of all the cases, 25%, were sentenced at 17 months or below. So half of them were between 17 and 87 months. So in other words, only 1/4 of cases received a sentence above 87 months. Only 1/4 of those 12,000 were above 87 months. What this 192-month, and by the way, and the lowest, of course, was 0 months, no time. The 192 months, that represents what's called an upper bound. It's not the maximum. Certainly there are many people that receive much higher sentences than 192 months. What the 192 months, it's a calculation where any number above 192 months is considered a statistical anomaly or an outlier. There's something very unusual to that sentence where it doesn't fit, literally or statistically, within a normal distribution, or the distribution as calculated by the software. In other words, where most sentences are between 17 and 87 months, anything above 192 months, again, is a statistical anomaly, and that's something that a judge should really look carefully at. So now let's look at those individuals that are similarly situated to Mr. Manafort. And by similarly situated, we mean sentenced under the same guideline with the same offense level, the same criminal history. Those are the most relevant variables for purposes of the guidelines. So what we see here is that there were only 15 nationwide and none in the D.C. Circuit. The average sentence there was 266 months, and the median was 288 months. the minimum was only 108 months, and the maximum actually wasn't 470 months. This is a something that one must know about the Commission's data. The Commission codes life sentences at 470. The reason why is so that that number can be taken into consideration when doing an analysis. If they just wrote in life, for example, then people like me would not be able to analyze that data. It would be a non-existent data point. So they somewhat arbitrarily picked 470 months as equivalent to life. If you think about it, that most cases would be a life sentence, at least an effective one. So at any rate, 108 months to life in prison is what people received, those 15 that are identical to Mr. Manafort. But again, we're only looking at 15 here. So just like this, these other numbers up here, let me just go back real quick. Weren't all that meaningful when just looking at them by itself. We did a chart like this. Well, here we have the same problem. When you're only looking at 15, what does this mean really? How dispersed were those other 15? Well, because there's only 15, doing a chart, a box and whiskers chart, really isn't meaningful either. So we just look at the data itself. Let's just look at the data, and that's what this shows. And there's some very interesting things that you can glean from this. Well, first off is these drugs. Usually, like in a fraud case or a tax fraud case, there aren't going to be any drugs. But what immediately jumps out is most of these cases have a drug, some type of drug associated with them. And why is that? Because as it turns out, money laundering, especially high dollar money laundering, is primarily an offense that's committed by large conspiracies to distribute drugs, drug traffickers. That's who really gets hit with the money laundering guideline. So Mr. Manafort already is a very atypical defendant to be hit with a high dollar money laundering case. Because why? He wasn't a drug trafficker. And only 3 of these individuals had missing amounts here. And by the way, the reason why I have these yellow ones identified, as you can see here, the stat min, this variable, that represents a mandatory minimum that was applicable in that case. And as you can see, all but these 4 that are highlighted in yellow had a mandatory minimum. So, and that obviously can throw off the sentence, because if the mandatory minimum is 120 months, you can't get less than 120 months unless you're cooperating with the government and get a 5K or something along those lines. So at any rate, so only these 4 cases didn't have a mandatory minimum. One of them was a drug trafficking case. The other 3, we don't know if they involve drug trafficking or not, because the data there is missing. But what we can say is this one most likely did involve drug trafficking, because this person received a 5K. That's what this variable means over here, or this number for Booker CD. We can see the sentences here, 162 and 180 months those persons received. These 2 people, these other 2 people, where we're not sure if they involved drug trafficking or not, but they didn't receive a 5K. The 0 means they received a within guideline sentence, and sure enough, that's what they received, 336 and 405 months. So really, these 2 individuals, from it was a case out of the Northern District of Georgia and one in Colorado, are the most similar to Mr. Manafort. And of the nearly 1 million people that have been sentenced under the guidelines since 2006, at least through 2017, only 2 match Mr. Manafort. And those 2 do not give helpful data. So it doesn't look good for Mr. Manafort, at least at this level. But again, one of the things that he could argue when looking at the data is, well, look at all these people. They're all major drug traffickers, and arguably their conduct was a lot more serious than mine. So I should get a downward variance. By the way, I should add that by looking at this, nobody received a downward variance of those 15. Some received departures as a result of a government motion, and a 6 and a 7 here also require a government motion. Those are like the code 7 is for a 5K 3.1. I won't go into what that is at any, or 1.3. Excuse me, but those require government motions also. Those are departures that depend on the government as opposed to the court. So bottom line is nobody received a judge variance. No judge looking at these cases said, you know what, these guidelines are too high for whatever reason. I'm going to sentence below the guideline range. But like I said, what Paul Manafort's counsel could argue is, well, that all may be well and good, but what distinguishes Mr. Manafort from these individuals is the fact that he's not a major drug trafficker, that this offense conduct just involved money, strictly money, and hiding it for tax purposes, as opposed to distributing drugs or something of that nature. So that could possibly serve as a ground for a departure. But as I mentioned in my other presentation, I'll just reiterate here, probably his strongest ground for a departure or a variance is his age. Again, he's nearly, he's 69 in 3 months. He was born April 1 in the 40s, excuse me, I can't remember. Oh, here it is, April 1, 1949. So he'll probably be around 70, let's assume, by the time he's sentenced. At least here in the District of Columbia, and it really doesn't matter. He's much older than your average federal inmate. So when we look at his life expectancy here, it's only 15.8 years. This is a study I referred to earlier that indicates that for each year served in prison, a person can expect to lose approximately 2 years of his life. We throw it here on the chart. It's the same chart that you saw earlier that I used in the Virginia case. 5 years is really what his life expectancy is if he does in fact lose 2 years of his life expectancy for every year of prison. So in some very real sense, the District of Columbia cases is a rather academic exercise. And I should add, whatever sentence he gets there, under the way the guidelines work, it will be imposed fully concurrent with his whatever sentence he receives in Virginia. And why is that? Because under the guidelines, if a prior sentence involves conduct that's relevant to the instant offense, then the judge is supposed to impose a concurrent sentence. And of course, the conduct in Virginia is relevant conduct because it involved the tax fraud and lying, etc. Even though it didn't involve the fact that it didn't directly involve, or he wasn't charged with any of the acting as an unregistered foreign agent in that case, it really doesn't matter because relevant conduct is so broadly defined under the guidelines. At any rate, suffice it to say, any sentence he receives in D.C. will be imposed concurrent, and he's looking at the exact same guidelines that he's looking at in the Eastern District of Virginia. And frankly, for the same reason as I pointed out in the Eastern District of Virginia, even though we do not have a lot of data to compare, and the data that is there isn't helpful to Mr. Manafort, I'm still estimating that he's only going to get around 10 years, maybe a little bit more in this case, because it more directly involves this acting on behalf of a foreign national or foreign country, foreign government, I should say. And there's probably more stuff that we don't know about that'll come out at sentencing that could be aggravating factors. So my estimate here is more along the lines of 12 to 15 years he may be looking at. And that's not supported by, well, it's supported in part by data, because of what we saw earlier, looking at these cases of those that are most similarly situated to him. They're getting very serious sentences, anywhere from 108 months to life. But those that are most similar to him are getting, well north of 12 years and around 15 here and 20 here. And I'll leave you with this: his sentence will be capped by the statutory maximum. If he's convicted on all counts, he will have an 80-year statutory maximum. So certainly he will be within range of all these sentences here, except for the life one. He can't get life if the stat max is only 80 years, but he could get 80 years. If the guidelines were to call for that, then obviously the way I calculate the guidelines are not going to call for anywhere close to the stat max. But depending on the number of counts of conviction, that will determine his overall statutory maximum, and we'll have to wait to see what that is. Depends on what he's convicted of, or if he changes his mind and decides to take a deal, then I'll have to change this analysis. But at any rate, this is Mark Allenbaugh for SentencingStats.com. It's August 25, 2018. Thank you.